I call to order the Policy Committee meeting of September 9th, 2024. It is 6:01 PM, and we are in room D205. Present is Mr. Todd Hoffman, Ms. Erin Gensel, Mr. Peterson, myself, Claire Guth, Dr. Freeze, Dr. Ron Davis, and Dr. Shulu. And we have a great agenda today. We're discussing the transition of our current policy system to PSBA's policy system. And we're starting with a lot this evening. We have several policies that are related to board governance and board philosophy and procedures. And then we also have a Title I parental and family engagement policy to discuss, and then a public comment in board meetings. And then also a guidelines that were established in 1997 regarding Markham families and where students go to and how they, the guardrails on how they are selected into either Jefferson or Mellon Middle School. So Dr. Freeze, if you would like to begin.
Yes, thank you so much. So our first item that we're going to take a look at tonight is 918, Title I, Parent and Family Engagement. This is a policy that needs to be reviewed each year. And the policy that you see before you, that's PSBA format, is taken verbatim from PSBA. It does align with our policy KC, which was our, or is currently our policy for Title I and parent and family engagement. So when you take a look at this, you'll see basically the purpose, where it talks about what this policy is for, the definitions, the authority, the accessibility, delegation of responsibility, guidelines, and building capacity for parent and family engagement, coordinating parent and family engagement strategies, annual parent and family engagement policy evaluation, which is this, school parent and family compact, Title I funds, documentation of parent and family engagement practices. So though the words may not be verbatim from the KC policy, it does include all the information that was previously included in our policy. And Dr. Shulu, there was no changes to it. It was pretty much so.
Yeah,
as is.
it's exactly what the PSBA recommendations were. This also is part of some corrective action from an audit that is due October 11th. So that's another reason why we put it on this week's agenda, or this month's agenda.
That's great. Thank you. Does anyone have any questions, Mr. Hoffman or Ms. Gensel, regarding this policy? Great, then we can move that to next week's voting meeting.
So the next ones that we're going to take a look at are the 000s. We're going to begin with the local board procedures. Previously, this board policy was known as Policy BG. This particular policy is board policy, procedure, and administrative regulations, and it basically gives you the parameters in which daily operations of the school district are to be governed. And in this, it gives basically, again, the overview of the authority of school board members, the contents of what the policy is. Policies of the board shall consist of the policies and procedures adopted by the board and contained in the policy manual, and such other separate documents approved by the board that are expressly incorporated by reference in particular policies and declared to constitute board policy, such as Code of Student Conduct. Administrative regulations are not part of board policy and may be altered by the administration without board action. Administrative regulations may not conflict with board policy or with applicable law. This policy goes on to talk about the limitations. All board policies and admin regulations shall be interpreted and administered in a lawful manner. The board shall make the final interpretation of its policies, and the administration shall make the final interpretation of its regulations. Board policies and procedures and admin regulations are limited by legal constraints, as are the rights of those whom board policies and administrative regulations apply, and are not intended to give an individual a cause of action not independently established in law. And then further here, it talks about the rule of construction. that neither the board nor the administration intends a result that is absurd, impossible to execute, or unreasonable in these policies, that neither the board nor the administration intends to violate federal or state constitutions or any other applicable law as they create these policies. And I think that's really important because we are bound by law to follow federal and state constitutions and any applicable law. And then the next piece here, you will see that this information was taken from our previous policy and inserted here just to kind of give an overview of board policies and what they look like. So, for instance, in this first paragraph, it talks about board members, residents, and taxpayers, employees, students, and the solicitor of the district may suggest proposals for new policies or revisions to current policies. Suggestions should be presented in writing to the superintendent, board president, or policy committee chair, any of whom should then refer the proposal to the policy committee for evaluation. And then it talks about how the policy committee, the solicitor, and appropriate staff will review and research the suggested policy, make any recommendations for change, and draft a policy for the board to consider. And then, since all policy committee meetings are public, comments on specific policies are welcomed and should be directed to the superintendent or the policy committee chair for consideration in accordance with this policy. In addition to this, it talks about that our solicitor will review all proposed policies before the full board discussion, and after the policy committee has recommended a policy to be presented at a discussion meeting, the board shall discuss the proposed policy, request additional information or clarification, recommend amendments, additions, or deletions. And once it's satisfactory from the board, we can move it forward for approval. Under unusual circumstances, the board may temporarily approve a policy to meet emergency conditions. However, the proper procedure shall be initiated as soon as practicable. Policies have historically been codified using the system of the National School Board Association, but moving forward, we will be using PSBA. And then the next part here talks about administrative regulations and the role that they play, which is basically they are developed by the superintendent or under the superintendent's direction. The board reserves the right to review admin regulations issued by the administration at its discretion, but shall revise or veto such administrative regulations only when, in the board's judgment, they are inconsistent with policies adopted by the board. Board shall be provided copies of all policies and admin regulations issued by the administration. If any policy or procedure or administrative regulation can be given multiple interpretations, the board and the admin intend that only constitutional and lawful interpretation shall be valid, and that neither an unconstitutional nor an unlawful interpretation was intended. The next part here talks about the policy manual access. Our board docs allows us to keep a policy manual that's accessible to anybody at any time. And these basically remain the property of the district as we create them. And then in terms of delegation of responsibility, this section here talks about the responsibility of the administration to implement and enforce the policy and to develop admin regulations for implementation or enforcement when necessary, that the superintendent or designee shall maintain an orderly plan for promulgation of policies and admin regulations to students, staff, parents, guardians who are affected by them, and that the superintendent or designee shall be responsible to review existing policy and admin regulations in light of board actions and revisions to state and federal statutes and regulations. Sorry, that was a lot.
That was a great overview. Thank you. Yeah, I think this particular policy is really catered towards creating more transparency and like better guidelines surrounding the public's interest in like wanting to create a policy or see how it works. Does anyone have any questions? Ms. Gensel, Mr. Hoffman, Mr. Weiland? We're talking about policy logs.
Not really a question, but just kind of to review for anyone who might be listening. So the administrative regulations, we've never had this before, correct? In the district, we've never had this kind of setup.
That's correct.
And then as we go through revising all of these policies to align with the PSBA, is there any kind of timeline to have the administrative regulations out there? And then the other question would just be, are there regulations, and again, this is just for anyone listening, associated with every policy, or or just certain policies?
The majority of policies, not all of them. For instance, like this one may be a smaller administrative regulation. We're currently working on the one for the policies that we did in August. They'll typically take about maybe 2 months to get completed, just because we're trying to be more purposeful about what we're doing. And you are correct, in the past, it was not something that we necessarily put into writing, but we believe that putting it into writing will help to provide consistency across the school district and implementation.
Thanks.
It's a lot of work, is what I would
Yeah,
say, and you want to get it right.
Well, and we appreciate it too. I think the more details, the better. I think that's great.
Great. And then moving on, we are going to discuss the name and classification policy 001.
So this one's a little bit of a shorter policy. This one is name and classification, and it's basically stating what the school board will be known as. So we will officially be known as the Board of School Directors of Mount Lebanon School District, here and after sometimes referred to as the board. And you will see in here, it talks about like what the composition is, which is the Mount Lebanon municipality, what the purpose is, which is that it's organized for the purpose of providing a program of public education to serve the needs of students in the Commonwealth. And then it talks about the legal status, that we constitute a corporate body that possesses all the usual powers of a corporation for public purposes, and in that name may sue and be sued, purchase, hold, and sell personal property and real estate, enter into those obligations that are authorized by law. The district shall be operated in accordance with constitutional and statutory provisions. Responsible for interpreting these provisions shall lie with the school board, except where formal interpretation of such provisions has been made by the courts or other constituted authority. It talks about how we are a member of the Allegheny Intermediate Unit number 3. That's what we're assigned to, that we are classified as a school district of the 3rd class. And then it talks about our organization from a standpoint of the education that we provide. We have an elementary school program, grades K to 5, middle school grades 6 to 8, high school 9 through 12, and other classrooms or programs as the board may authorize the district administration to establish. And then the official address, which seems to be missing from here, but the official address of the school district, which is 7 Horseman Drive.
Perfect. Any questions? Okay.
One note on this one, we're actually a school district of the 2nd class. The cutoff is 30,000 residents.
Okay.
So anything over 30,000 residents and less than 250,000 residents is a school district of the 2nd class.
Okay.
So if we could just
I
correct that.
updated that.
And then I did note that there's just some duplicate words in the first sentence. It's Mount Lebanon School District, School District. You see that? It's in,
Yep,
school
done.
district is in there twice. Other than that, this is one of the policies that's, quite similar to the old one. The old one had a little bit more in it, but not that was necessary.
Perfect. All right, we will move that to vote next weekend. The next policy is 002, authority and powers. And
So for this one, 002 title, the title is Authority and Powers. And it's the authority is the authority to establish, equip, furnish, operate, and maintain the public schools of the Mount Lebanon School District as vested in the Board of Directors, which is a body corporated as constituted and governed by Title 24 of the Pennsylvania statutes. Underneath here, it talks about that the board shall establish such schools as are required for the education of every student residing in the district between the ages of 5 and 22 years of age. That we will act as the general agent of the residents of the school district in matters of publication. That the board, in accordance with its statutory mandate, shall adopt board procedures for its own operation and policies for the guidance of the superintendent in the operation of the school district. That the powers of the Board of School Directors are not vested in the individual board members. No such individual is authorized to act on behalf of the board to carry out any of the board's authorized powers except for those acts stated in the law. An individual board member exercises the authority and responsibility of their position only when the board is in legal session. The board will be not bound in any way by any statement or action on the part of any individual board member, except when each statement or action is in pursuance of special instructions or authorization by the board. Within the capacity of board membership, individual board members shall represent the best interest of all the schools in the district. They'll suggest issues for board consideration, inform themselves on school matters, take part in board deliberations, arrive at opinions independently, and vote as they choose. Each board member shall be committed to reaching and supporting group decisions that represent the best judgments of the board as a whole. And it does not preclude a board member from voicing a minority viewpoint, but such should be indicated as personal, not board opinion. Individual board members should refer all complaints or requests directly or indirectly relating to instruction, personnel, or services to the superintendent. Individual board members shall refrain from publishing, distributing, releasing, or disclosing any documents, records, or information containing or reflecting the pre-decisional deliberation of the board relating to matters such as budget recommendations, legislative proposals, or any contemplated or proposed policy or course action. The preclusion includes any research, memorandums, or other documents used by the board in its pre-decisional deliberations. And then next, it kind of states the role of the board. It states clearly defined, articulate, and adopt the mission of the district with input from district stakeholders, develop the long and short-term goals of the district, develop, maintain policies for the effective and efficient governance and operations of the district, monitor the overall performance of the district on a continuing basis, employ a superintendent to manage the district and regularly evaluate their performance, be an advocate for public education and children, comply with all laws, rules, and regulations relative to the district. And then the next section here kind of highlights the responsibilities, top priority to attend all meetings, executive sessions, administrative briefings, workshops, committee functions of the board, cooperate with other board members in defining what information is needed to appropriately address an issue, prepare for all meetings and activities by reviewing background material made available to them, contact the superintendent when clarification or additional information may be needed, direct media inquiries concerning an official district position to the board president, superintendent, or official designee. However, that does not preclude board members from providing their personal opinions so long as they are identified as personal views. Notify the board president when a member will be unable to participate in a meeting or other board activity. Assume responsibility for the following when unable to attend a meeting or activity. Advise the board president of their position on significant issues to be discussed at the meeting. Assume responsibility to learn what transpired at the missed meeting or activity. Accept all decisions of the board that were made at the meeting or activity. Articulate their position and rationale on all major issues being deliberated by the board. Advise those who may hold a majority position on an issue what modifications would be necessary relative to their position in order to receive one's support when holds a minority position on an issue. And then honor all decisions of the board after due deliberation unless a decision is unlawful, immoral, or unethical. And that is for that policy.
Great, thank you. I really appreciate this policy and the guidance associated with it, all of this. Does anyone have any questions or comments?
It looks like the gender or the pronoun feedback that I provided was already addressed.
Yes, when you
Right.
sent it.
It's already in there? Yeah. Nice.
What was really interesting is the majority of it was done, but we missed a couple of them. and I
Yeah,
don't
there were
know
just
how.
a few
Yeah, but we fixed those.
in a couple of them. Great.
Move fast. It's impressive.
If you don't do it, then you won't
Yeah,
remember to
that's
do
true.
it, so
Yeah.
it's easier just to do it.
Great, then moving on, 003, which is functions.
Okay, 003, which is under functions, is the board shall exercise leadership through its rulemaking power by adopting board procedures and policies for the organization and operation of the school district in accordance with policy 000. The board may, upon a majority vote, cause to suspend at any time the operation of a board procedure or policy, provided the suspension does not conflict with legal requirements. Such suspension shall be effective until the next meeting of the board unless a different time is specified in the motion to suspend. Board policies and procedures shall be adopted, amended, or repealed by a majority vote of the board. Adoption, modification, repeal, or suspension of a board procedure or policy shall be recorded in the minutes of the board meeting, and all current procedures and policies shall be maintained in the board policy manual and disseminated properly. And then in terms of the executive section of this policy, the board shall exercise its executive power by the appointment of a district superintendent who should serve as the chief executive officer of the district and enforce the statutes of the Commonwealth, the regulations of the State Board of Education, policies of the board, and all other applicable laws and regulations. The superintendent's responsible for implementing board policies and establishing administrative regulations for the operation of the school district that are not inconsistent with state and federal statutes or regulations, are dictated by the policies of this board, are binding on district employees and students when issued, and shall be committed to the board for review. Board reserves the right to alter or rescind any such administrative regulation. And then it just further goes into here, just some information about direct revisions of administrative regulations when it considers the regulations to be inconsistent with board policy or district practice, that the board reserves the right to review those and direct revisions. The board shall not adopt administrative regulations unless required by law or requested by the superintendent. And such adoption or amendment of administrative regulations shall adhere to the policy or for adoption and amendment of board procedures and policies. And then the last part of this here kind of delineates, though not an exhaustive list, board responsibilities and superintendent responsibilities. This is something that I believe was in one of our previous policies, and it basically goes through and highlights what board responsibilities are, what the superintendent responsibilities are. There's so many of them that I feel like if I read all of these, we'll never get through all the policies, but they are available to the public for view. And then the next section of this policy talks about review. And in this section, the only addition from the PSBA policy is under in furtherance of an adjudicatory function, the board may hold hearings either before the board or where appropriate under applicable law before a committee of the board or a hearing officer in accordance with law, which shall offer the parties to a dispute on notice duly given, a fair and impartial forum for the resolution of the matter. And then the final thing is evaluation of board procedures. Board will review and evaluate its functions as a board when deemed necessary by the board president. The board may evaluate board procedures, relationships, or activities, or focus on a particular area or issue. The board president, working with the superintendent, may develop an annual plan to review and evaluate board functions.
Perfect. Any questions or comments? Great, then we can move this next week to vote. And the next policy is 004, membership.
Hey, Claire,
Oh, yeah,
can I,
sorry.
and I am not an English teacher. But should it be or a hearing officer? Or
Bottom.
is it an if it's like heirloom, but a hearing officer if it's, it's like, call me the grammar.
My vote
The
is,
col-
my vote is,
Yeah, it doesn't matter, or maybe it does, but,
I,
Yeah, I
could-
think you're right.
okay.
yeah. Because
I don't know,
pretty
I just looked it up
pretty
because
sure
I was
that-
like, that doesn't sound right.
our office was involved in adding that, so I'm sure that's a typo on our end.
We won't hold Tucker accountable.
I made that correction. All right, the next one is 004, membership. And here it talks about that the board shall consist of 9 members. The superintendent should have a seat on the board and the right to speak on all matters, but not the right to vote. It talks about in here what your qualifications are to be a school director, which is good moral character, at least 18 years old, resident of the district for at least 1 year prior to their election or appointment, not a holder of any other office or position as specified in section 322 of the school code, shall not have been removed from any office of trust under federal, state, or local laws for any malfeasance. I'm going to ask my legal consultants here because I don't think I've ever used that word before. Shall not be engaged in business transaction with the school district, be employed by the school district, or receive pay for services from the school district except as provided by law. Shall take and subscribe to the oath or affirmation prescribed by statute before entering the duties of the office. Shall file the statements of financial interest with the board secretary designee before taking the oath of office, annually by May 1st, and by May 1st of the year after leaving the board. Election of the members of the board shall be in accordance with law. And then the next section here kind of talks about vacancies, if they were to occur due to death, resignation, removal from the district or region, that they be filled in accordance with the school code and Sunshine Act. It also talks about the temporary vacancy plan for somebody who's in active military service. And then it talks about the procedures that would be taken in order to fill that vacancy. So announce the existence of the vacancy on the board in the newspaper or newspapers, request that all interested candidates submit a resume of qualifications to the superintendent, review the resumes of all the candidates, at one or more public meetings, interview all interested candidates, nominate one or more candidates, proceed by roll call vote to elect a new director to fill the vacancy. In the event the vacancy to be filled is for a period of time less than 1 year, an exception will be made to the use of this policy and other considerations and procedures, followed by the appointment of the new director. It also talks in here that the term of a school board director shall be 4 years and shall expire on the first Monday of December, unless except for a school director appointed or elected to fill a vacancy. It also talks in here about removal, when a school director is no longer a resident of the Mount Lebanon School District or the region that represents the eligibility to serve on the board will cease. If a school director neglect or refuse to attend 2 successive regular meetings of the board unless detained by sickness or prevented by necessary absence from the district. If a person elected or appointed as a school director have been notified shall refuse or neglect to qualify as such director, the remaining members may, within 10 days following the beginning of their term, declare said office vacant on the affirmative vote of a majority of the remaining members of the board. The next section here talks about expenses. Board members, a non-member board secretary and solicitor shall be reimbursed for necessary expenses incurred as delegates to any state convention or association of school directors convention held within the state, or for necessary expenses incurred in attendance with a board authorized by the board at any other meeting held within the state or educational convention of out of state. Advance payments may be made upon presentation of estimated expenses to be incurred, to be followed by a final itemized verified statement of such expenses actually incurred, and a refund shall be made to the district of such funds remaining, or an additional payment shall be made to, basically if those expenses are over what they were expected to do. No school director shall be reimbursed for more than 2 out-of-state meetings in 1 school year. The next section here talks about the orientation of new school board members to the board. And in this particular section, it talks about making sure that new school board members understand the functions of the board, acquire knowledge of matters related to the operation of schools, and review board procedures and policies. And then in addition to that, board shall give to each new school director no later than their first regular meeting for use during the term on the board the following items: school code, board policy manual, current budget statement, audit report, related fiscal materials, access to district information on comprehensive planning, curriculum assessments, facilities planning, and district programs, and then a copy of the board's adopted principles of governance and leadership. Each school director, new school director will be invited to meet with the board president, superintendent, and board secretary to discuss board functions, procedures, and policy. The next section here talks about school director education and training, and it talks about the importance of planned and continuing program of in-service education and training for its members. In conjunction with the superintendent, the board shall plan specific in-service education programs and activities designed to assist board members in their efforts to improve their skills as policymakers, expand their knowledge about issues, programs, and initiatives affecting the district's educational programs and student achievement, and deepen their insights into the nature of leadership, governance, and community engagement. And then the school shall be kept informed of the board's continuing in-service education and training, and what the benefits of it, both short and long-term, are. In addition to this, it gives just some more information about conference attendance and what the purpose of the board is when they attend those conferences. And then it also talks about student representation, which authorizes student representation at the board in order to facilitate effective communication and to provide an opportunity for students to participate in school governance.
Great, thank you so much. Does anyone have any questions or comments?
I guess just, and this may be administrative regulation territory, but student representation on the board, what does that look like, or what's the vision there?
Well, right now, what it looks like are the students that come and give presentations, each voting meeting. But if I was to tell you what I'd like to see long-term, it would be to have student representatives on the board. They wouldn't be able to vote, but they would be able to come
Right.
and speak. In my previous district, we had that, and it was very informative. And we would create a process for selecting those individuals with the goal of that being next school year.
I think it's a great idea.
Absolutely.
I think, to your point, it does require, some written construct, because obviously it doesn't expand who gets confidential information, those sorts of things. So I think the fact that it is a component of meeting on whatever schedule you conclude, plus presenting at the board, but we can certainly work with you on clarifying all that.
Absolutely, and they would attend meetings, they wouldn't get things in advance, they would have access to the public documents. But they are really fantastic ways to get students involved in governance before they become adults. And they're very helpful and candid about things, which I always find to be the best part of them being on boards,
And as we witnessed, there's some really exceptional students out there.
without a doubt.
Yeah. We're not able to add under the qualifications any sort of like stipulation that requires child clearances or FBI clearances. Are we, Mr.
Well,
Peterson?
the requirements are statutory. Now, if a school board member was going to, have direct access and contact with students, then all of those normal rules would still apply.
Okay.
But we're not allowed to add a condition more than what's in the school code.
Thank you. Just curious. Great, then we can move this forward for next week. The next policy is 005, which is organization.
005, organization correlates to our policy BDA, and this talks about that the board shall meet and organize annually during the first week of December. Notice the time and place of the organization meeting shall be given to all board members by mail, which I think is kind of funny. I was wondering, do we have to mail it to them, or could it be email?
Well, there's cases that hold that email constitutes notice. And in fact, the board, of course, it votes on that every organization meeting. It picks the date of the next board meeting, and then that is constantly available on the calendar. So what you do is adequate. It's the 5-day thing that has tripped up a few districts, where the first time it's in writing is in a packet on a Thursday, and Monday's only 4 days away, and it causes a little problem. But no, we're fine with that, because the board sees the date so many times throughout the year.
Okay, thank you. I just read that, and I was like thinking earlier, yeah, we'll send everybody a written invitation. The organization meeting shall be called to order by the current president or vice president of the outgoing board, or any holdover member of the board. Temporary president shall be elected from among the holdover members. Board secretary shall be secretary for the meeting. In an election year, certificates of election or appointment of all new board members shall be read, and a list shall be prepared of the legally elected or appointed and qualified board members. At the organization meeting, the temporary president may administer the oath or affirmation of the office to those board members who have not previously taken and subscribed to the same. And then the next section here talks about officers, and election of officers shall be by the majority of vote of those present and voting. Where no such majority is achieved on the first ballot, a second ballot shall be cast for the 2 candidates who receive the greatest number of votes. School directors shall annually, during the first week of December, elect from their members a president and a vice president, who shall serve a 1-year term. School district or directors shall annually, during the month of May, elect a treasurer, who shall serve for 1 year, beginning the first day of July after such election. This treasurer may be a corporation duly qualified and legally authorized to transact a fiduciary business in the Commonwealth, and may be a member of the board. The treasurer shall not enter upon their duties until furnishing a bond in accordance with law and with board approval. School director shall, during the month of May and every fourth year, elect a secretary who shall serve a term of 4 years, beginning the first day of July following such election, and may be a member of the board. Secretary shall now not enter upon their duties until furnishing bond in accordance with law and board approval. Vacancies in any office shall be filled by board election. Same school director may not hold more than one office of the board, and no commissioned officer or professional employee of the board shall serve temporarily or permanently as an officer of the board. Officers of the board serve at the pleasure of the board and may be removed from such office by the affirmative vote of a majority of those present and voting. A board shall have the authority to appoint a tax collector, a solicitor, a right-to-know officer and coordinator, independent auditor, delegates to a state convention or association of school directors, other appointments the board deems necessary or may be required by law. Appointees serve as the pleasure of the board and may be removed from such appointment in accordance with provisions of law. And then in terms of resolutions, the board may at the organization meeting, but shall prior to July 1 of the next year designate newspapers of general circulation as defined in law, normal day, place, and time for regular meetings, normal day, place, and time for open committee meetings. And then the next section here talks about the board committees and the president of the board's authority to designate all board committees. No official action is authorized to be taken by any committees or to report their recommendations to the board at a public meeting, such as we're doing this evening. And then further here, it basically just lays it out in terms of like how those committees will work. A member may request or refuse appointment to a committee once they are nominated by the president. The refusal to serve on any one committee shall not be grounds for failure to appoint a member to another committee. Each board committee shall be convened by a chairperson who shall report for the committee and be appointed by the president. The person first named on the committee shall be considered the chairman. In case of absence or inability, the second named person on the chair or on the committee shall be named the chairman's place and perform their duties when they're not available. Committees may, at their discretion, request the attendance of the solicitor at their meetings. Chairman of each committee shall report on the status of committee assignments at each business meeting of the board. Each committee chairman shall arrange the necessary meetings for the conduct of committee's work and provide notice of the meetings in advance to all board members and others who should be in attendance. Committee meetings called for the purpose of deliberation shall be open to the public. All relevant policies concerning board meetings shall be applicable to committee meetings in the same manner as applicable to board meetings. And then all members of the board are encouraged to attend any committee meeting, whether or not a member. It further goes on to talk about creating ad hoc committees. They can be created, charged, and assigned a fixed termination date, which may be extended by the president. Members of the ad hoc committee shall serve until the committee is discharged, and the board may develop board operating guidelines to describe the duties and establish procedures for the operation of standing committees. The next few things here talk about board representation or board representatives. The president may appoint as soon as the organization meeting as practicable representatives of the board to serve outside boards and committees where they shall serve a term designated by the board. In addition to that, the board can appoint, employ, or retain consultants to provide the district with specialized services not normally required on a continuing basis. And compensation shall be determined and approved by the board. The function of a consultant shall be to make studies and present recommendations to the board, and the consultant should not be charged with the implementation of a report. And it further goes on to talk about that a consultant has no administrative authority, and the use of consultants from outside the district to promote a particular commercial product is discouraged. That's the extent of that policy.
Great. Any questions or comments?
Yeah, a couple of gender and inclusivity issues here. Chairman, if we can change chairman to chairperson. It's on there 4 times on page 3.
Okay?
But that's it.
Is that it? Okay.
Thank you.
A couple substantive things. As we go through this policy, I'll try to point out an area where there is actually a difference between PSBA's approach and the policy we have. So, for instance, our policy, this is just a preference that school boards in the past have rolled into the policy. if you note on the first page, under the paragraph called order, the second paragraph says at the organization meeting, the temporary president may administer the oath to those board members who have not previously taken it. Mount Lebanon Board decided many years ago to add this language: the holdover president or a designee will arrange for a local judicial officer to administer the oath of office to new directors. And in the absence of that official, the temporary president may administer the oath. So it would be a question initially for this committee and then for the board as to whether you wanted to retain that. The thought was to add an air of formality. You know, we would have a magistrate, or very often a federal or state judge, who would come, swear people in, make some comments, have photographs with the family, and, you know, it's a pretty important event, and the board concluded that they'd like to see that requirement. So we could work that back into this one if the committee would like us to, or you can. I mean, it's in the current policy BDA. And the other practice that the board and many boards have developed is policy BDA provides that the solicitor will be elected at the reorg meeting. This policy doesn't mention that. Some districts don't have a term. It's just there's an appointment. So if you wanted to keep that annual element as a part of the agenda, then again, whether you do it or we do it, it's in policy BDA, that be an agenda item.
If the solicitor falls under a contract, would that apply also, or would it be to the contract year?
If you followed the old practice, the term would be until the next reorganization meeting. That's what it's always been. So, I mean, you could have any discussion about, fee matters having to be on the school district's fiscal year. And, quite frankly, you could have a solicitor appointment tie in directly with the fiscal year. But I think the thought has always been, at the same time that new board members are being appointed and officers are being elected, that made sense to be a time, because it's the board's, technically the solicitor to the board that's being, appointed. However the board would want to proceed in terms of how this policy reads on that topic. The only other thing I noticed here is our agenda does not provide on a reorganization meeting, for the designation of a newspaper of general circulation. That's in the PSBA policy. It's not required by law. So my only note would be that if the board would like to do that, which is fine, Post-Gazette's the only newspaper of of general circulation here, just to make sure that Mrs. Walters knows, because, we have a pretty standard agenda for that meeting. We just would want to make sure that we add that, so we're not running afoul of our own policy.
Thank you for those suggestions.
So generally, on the first one in particular, I think it's a good practice. We have not had difficulty, in my experience, identifying, as Mr. Peterson pointed out, either a state, federal judge or magistrate to serve in that capacity. So I would like to see that in the updated policy.
And again, we would keep the language that if for some reason somebody
Sure,
couldn't
we still
or
leave
failed
the
to
option
attend.
open for the
Yeah.
temporary president to fill that role. Regarding the other, I mean, the newspaper of general circulation, again, as long as we're in compliance, but if it's not required by the school code, I don't know that we want to potentially impose something upon ourselves that, we could run afoul of at some point along the way.
I think this probably was developed in communities where there's multiple options.
Right.
But as long as I've been around here, we've always known, you run your advertisements in the Post-Gazette. I don't think it's necessary. And I verified, I just made sure I read the statute, because I was a little surprised to see that. And the statute doesn't mention the board approving. It just says there is such a thing as a newspaper of general circulation.
Sure. And then regarding the appointment of the solicitor annually, I mean, I'm neutral on the point. I mean, I know we're going
yeah, if anybody has a strong argument, you know, one way or another.
And again, several of our districts do that. Several of them don't have it tied to any particular
Sure.
period.
Tom,
It's the first vote of all the new board members, and they've had all of 5 minutes to think about it.
Sure.
Mrs. Connolly, would this help with like forecasting if it was aligned with the fiscal year?
Yeah, I guess it could.
Mr. Peterson, what was the impetus of that procedural
Well, it
practice?
was there when I arrived, and again, I think it was just the idea that it allows a new board to select a new solicitor. That's the real genesis of it. And, you know, that hasn't been an issue here, but if you had a complete wholesale change, you know, there are some districts, of course, where the quite frankly, solicitors can change every election. And so if there's a shift of a few votes, I think the thought was that new board have the ability to select their new solicitor if they want to.
Sure, and certainly I believe that makes sense.
I think the only thing that concerns me about that is like the practicality of that. Like that solicitor then would be done that December, right? And
Yeah.
so we'd have to find somebody by January?
Well, no,
If
you
that
would,
was
you
to
would do
happen.
this before and appoint the person at the meeting. So,
But they would have only been in office, those new people, for like,
5 minutes.
right? That seems like a really unfair,
Yeah, I think
Potential.
the realistic, the facts of the situation are normally, there are individual discussions with people prior to the meeting. Now, again, some boards resolve that by just saying that the solicitor serves at the pleasure of the board. And a solicitor appointed in October could serve 20 years, could serve 4 months, you know, it's not a contract that has a term. It's not, like, for instance, you'll hire your auditor for a 3-year term. And I guess you might get a legal proposal for a contract for a term, but I think the more standard view is it's a very sensitive position, and it's totally unworkable to have, say, a solicitor for 2 years remaining on a term who's not aligned with the new board. So the structure of this one is just that, is it just allows the board to select a solicitor when it wishes, and then when a majority of the board feels that there should be a different solicitor, they can do so, with as much prior planning as they wish then.
Sure. So I would agree with the analysis regarding the pitfalls of signing an attorney to a term contract, considering the sensitivities. And I understand the argument about affording the new board the opportunity to select their own solicitor, you know, especially in an example where there might be a wholesale change to the makeup of the board. However, the practical reality of that, as Dr. Freese pointed out, is that, you know, these folks have been in that position for a minute and a half. And, you know, there hasn't been any meaningful, you know, vetting or review of potential candidates. It's here's the candidate, vote. And look, and I'm very appreciative of, you know, our sort of Pittsburgh Steelers methodology to solicitors, as Mr. Peterson has, you know, held that chair with distinction for more than 4 decades now.
Well, 3 decades in that chair and 13 years in the chair here next to, I was the assistant for 13 years, but yeah, and, you know, it hasn't come up formally, but there certainly has been discussion. I mean, there's been 1 or 2 board members who maybe jokingly, maybe didn't, after being sworn in, saying, I voted on that based on no information,
Yeah,
you know, other than the majority of the board indicating, and then I'm going to defer to the majority of the board. If there's 5 or 6 or 7 people that feel this way, then, you know, I'm not going to overrule that on my first official vote. But,
so I assume it's necessary for the board to take action and appoint the solicitor at some point.
well, technically, you know, the school code says you may, but I don't know a school district that would operate without a solicitor. And you know, you want to, at all times, have an attorney-client relationship. I mean, in the instance here, the solicitor position is, you know, from a breadth of services position is quite narrow. That's in my role as solicitor only, I attend board meetings, which is a tiny, tiny percent of what we do. And then the school district also has an engagement letter with Tucker Arnsberg. So theoretically, that could change and the solicitor could stay the same, or vice versa.
Right.
But you know, it's becoming more and more common that when a solicitor is appointed, that it's a law firm, with the board, though, identifying what person or people in that firm it expects to get its services from. So if you were to change it, then, you know, currently, the term expires December 4th, 5th, 6th, whatever that day is. But if the board wanted to change that, then the solicitor vote on that day just wouldn't have an end date.
Sure.
And it could certainly become a matter of practice or even written policy to review it at a certain time. You know, like the treasurer comes up every 4 years, you know, but a lot of districts just don't have any reference to a term because they want the ability, as soon as a majority would prefer another solicitor, that they don't have to declare a breach, they don't have to show cause for termination, it just has to come up at a public meeting.
So, I mean, generally speaking, the solicitor serves at the pleasure of the board. So
Yes.
at any point in that professional relationship, the board can pivot,
Right.
right? And it's not necessary under the school code for there to be some, you know, a public appointment like that.
Well, yeah, it requires a board vote,
Okay.
but it can be, I mean, there's no notice period. If the board decided that it wanted to make a change, then in our situation, it could be in an agenda for a discussion meeting and an action at a regular meeting. And there would be no requirement of any sort of advance notice.
I think, I mean, generally, I think that there's value in the transparency of the, you know, discussion and vote for such an important position, right? But I recognize that the timing of it, you know, that you're asking folks to vote on something that they have very little information on to cast such a vote at the reorganization meeting. Is it better timed at some other time during the year? Oh, but
Well, again, I mean, it's, to a large degree, I know the board's goal here is to adopt what PSBA has recommended. There's a lot of data, of course, that's gone into this, and what I've been trying to do here a couple times is just point out where ours is a little bit different in case you'd like to keep it. But
Sure.
no, I think, you know, getting back to the idea that the practice of appointing at the reorg meeting was tied to the fact that a brand-new board majority might want a new attorney. I mean, we can certainly wait 1 month, you know, if you did want to give people more time to think about it before they vote.
Forgive me, everybody here at the table and the audience and listening at home for thinking through this sort of in real time, but I think ultimately where I'm landing in this discussion, Mr. Peterson, is to keep it as is, to do it at the reorganization meeting, and then to the extent, because it is a, you know, at the pleasure of the board service, you know, if there's an appetite for, you know, a new board to make some kind of a change, then, you know, give them a minute to do their due diligence and whatever is necessary to arrive at that decision.
Yeah, I think the only thing you'd need to do is reword, because the current resolution, legally, it's at the pleasure of the board. The current resolution states serve until the next reorganization meeting. So I think what you'd want,
Could we just add a clause that gives the board some out during that time, or?
or just remove that language. You know, you could just, currently, everything is set up, that meeting's not too far away, right? I mean, it's
Sure.
first meeting in December, so for this year, you could still keep it there. And maybe rather than saying until the next reorganization meeting, just say, so-and-so is appointed solicitor until further action by the board.
Yeah, I think I like that. I don't know, other members of the,
If we keep just solicitor, so like the language for PSBA, just number 2, the board shall have the authority to appoint solicitor. I mean, can that necessarily, that could still be December, couldn't it? It doesn't specify a date.
I think, yeah, if you leave it as is, it just means that you have the right to appoint a solicitor. You don't have to add a date to when you do it, right? Technically.
No, I mean, the question is whether you take action to say it will be an action item because this meeting is this entire policy is only about the first meeting of December every year. And so and again, the current language says, the solicitor shall be voted on or appointed for the upcoming year at the reorganization meeting. So, although, so the district is sort of creating a term requirement that isn't otherwise in the school code. So, I mean, if we said appointed until that date, unless the board determines otherwise,
yeah,
that's still created a situation, though, where the next December, some people are going to have to vote on something that they've had, and they've only been in office for 5 minutes. You know, if that's the end of the term, unless terminated earlier.
well, I mean, it's necessary to do it in a public meeting. It's
Right.
necessary, I think, from a transparency perspective, to have such a discussion and a vote. You know, it just, to me, while it's imperfect, it's the beginning of a new year of board service. It's the appropriate time to sort of
Well, I mean, you know,
re-up that agreement, but if you add the clause that you just described that says until the next reorganization meeting or further action by the board, you know, not necessarily creating a one-year commitment, because the board certainly has an at-will ability to change that.
yeah, I mean, you could provide that. I guess the question, though, is do you want to get away from having new board members voting on a solicitor right after they've been sworn in? If so, I mean, you could move this to be a June thing, and tie it, you know, to the end of a fiscal year if you wanted to. There's no, you know, requirement. And again, some boards, because they just, whenever they want to, they appoint a solicitor. The solicitor stays in that position until a new solicitor is appointed. It doesn't matter what month of the year it is. It doesn't matter how long it's been. But again, our current language does create that one-year term, so we would definitely need to do something there. It's just a question of whether you want to move it off that reorganization agenda to avoid the situation I mean, it could well be at some point that someone who's just sworn in just says, I have to abstain. I've never met this solicitor.
Sure.
How can I vote?
So maybe fiscal year is a good compromise, you know, do it.
Yep.
What-
If you'd like, between now and next week, I could try to see if I can find any other examples of how people have done it. It's, I guess surprising isn't the right word, but this is pretty common,
Yeah.
what this district does, and it does require people, think about it, if that wasn't on there, the only thing that a new board member would be voting on is the calendar. Well, that's pretty non-controversial.
Past meeting.
Most years.
Yeah. Well, that's just your calendar, not the school calendar. So you know, as I said, there's a meeting, of course, coming up in December, so if you don't do something here, then
Right.
you'd have to at least revise that portion of it, and I'm not sure what, you know, the rest of the committee feels, or, because this would be something where, of course, the committee would have to make a recommendation.
Yep.
And then, you know, that most of the board is here listening, but then you'd still need a pretty full discussion next
Yeah.
week, and there may or may not be
Or in an hour,
consensus.
half hour.
Yeah, that,
Well, what do you, the rest of the committee, what do you guys?
Any comments?
Yeah, I mean, honestly, I have a lot of strong opinions, but not about this. I wish I had something to offer, but
Okay.
Yeah.
I really don't. You know, as a new board member, I did not feel, you know, having attended meetings for quite a while before I ran, I felt okay making that vote. The one thing that, you know, I think we don't want is to kind of actively look as if we're trying to politicize or encourage this sense of, you know, you can vote, you can get a new solicitor mid-year for whatever reason you want, even if that's within the right of the board. I think explicitly laying that out, I wouldn't want to encourage that kind of behavior because of the downside that I would see to, you know, flipping solicitors mid-year. It just feels like that could get very messy, and I think the current system works pretty well.
Great. Then maybe, I mean, if it is possible, if you do know of any other best practices.
yeah, I could see, and, you know, the other thing you could do too, because most of what's in here is identical. You know, we've discussed having the, you know, judicial, and we've discussed taking the newspaper out. So if you were so inclined, we could work if you wanted to stay with what you have now, just to get this policy adopted, you still have time between now and December to change it if you would like to. But I think, you know, to Mr. Hoppman's point, the one thing this does do is give a sense of, we know what's gonna happen when.
Yeah.
Yeah.
And you know, I could ask, all of you had to do it. I don't know if people were uncomfortable making that vote after being sworn in 2 minutes earlier or not.
Seemed like a good guy. So.
Right.
Great. Then,
Well, why don't I put that in there, if that's okay with you, at least for next week? But
Sure.
it's a topic that's been presented and could be discussed.
Well, we're going to have a discussion meeting here shortly, so
Yeah, yeah.
we'll highlight it for the rest of the board and see if anybody has
Okay. So
any strong feelings one direction or another.
I'll get that one to the administrative team, and, you know, tomorrow or Wednesday with those changes.
perfect. Great. Then moving on, 006 meetings.
Okay, the next one is 006, and for this one, it relates to meetings and how they will be operated. All will be conducted in orderly and businesslike manner using Robert's rules. A quorum shall consist of a majority of the members of the board. No business shall be transacted at a meeting without a quorum. Presiding officer shall preside at all board meetings, which is the president. In the absence, disability, or disqualification of the president, the vice president shall act instead. If neither is present, a school director shall be elected president pro tempore by a majority of those present and voting to preside at that meeting only. Where no majority is achieved at the first vote, a second vote shall be cast for two candidates who receive the greatest number of votes. In terms of meeting notifications, it talks here about how that will take place, including emergency meetings and executive sessions do not have to be advertised or posted. Under this here, it gives you like a list of 5 things that need to be considered for meeting notifications. First being a notice of regular meeting shall be given by publication and posting of schedule showing the date, time, and place of all regular meetings for the calendar year, at least 3 days prior to the time of the first regular meeting. Notice of all special meetings shall be given by publication and posting of a notice at least 24 hours prior to the time of the meeting, except that such notice shall be waived when a special meeting is called to deal with an actual emergency or involving a clear or present danger to life or property. Notice of all rescheduled meetings shall be given by publication and posting of at least 24 hours notice. Notice of all recessed or reconvened meetings shall be given by posting a notice of the place, date, and time of the meeting and sending copies of such notice to interested parties. Notice of all open meetings shall be given to the newspaper circulating in Allegheny County and any radio or television station which so requests. Notice of all open meetings shall be given to any individual or who so requests and provided a stamped addressed envelope for such notification. Notice of all rescheduled meetings and special meetings shall be given to each school director no later than 24 hours prior to the time of the meeting. And then in terms of agenda notifications, the agenda, together with all relevant reports, shall be provided to each school district director before the meeting. The agenda includes an item of business related to removal of an officer of the board. The agenda shall be provided to each school director at least 7 days before the meeting for vote. Is that for vote or just for the meeting? What, like, do we need to specify what meeting?
Well, let's see, it's before the voting meeting.
Okay.
Yeah, yeah. I mean, our discussion agenda is, you know, what serves that purpose.
Okay. District shall publicly post the agenda for all open meetings of the board or board committees at which deliberation or official action may take place no later than 24 hours prior to the time of the meeting. That is on the district's website, at the location of the meeting, at the district's administrative office. Posted agenda shall list each matter of agency business that will or may be subject to deliberation or official action. Agenda preparation is the responsibility of the superintendent in cooperation with the board president to prepare an agenda of items business anticipated to come before the board at each open meeting. Additions to the agenda, board may deliberate or take official action on matters not included in a posted agenda under only these circumstances: emergencies, business arising within 24 hours prior to the meeting. This is de minimis or minor in nature that does not involve the expenditure of funds or entering into a contract or agreement. Business raised by residents or taxpayers during the meeting. When a matter of the board business is raised by a resident or taxpayer during a meeting, and the board may take official action to refer the matter to staff if applicable, to conduct research. If the matter is de minimis in nature and does not include the expenditure of funds or entering into the contract or agreement, the board may take official action on the matter. During the meeting, the board may add a qualifying matter of business to the posted agenda by majority vote of the school directors present and voting. The reason for adding the agenda item must be announced at the meeting before conducting the vote. Once announced and approved by majority vote, the board may take official action on the item of business. The agenda shall be amended to reflect the new item of business, and the amended agenda shall be posted to the district's website and the administrative office no later than the first business day following the meeting at which the agenda was amended. The public posting of agenda requirements and rules for adding items to a posted agenda apply to both regular and special open meetings of the board. These requirements and rules do not apply to conference sessions or executive sessions. Regular board meetings shall be open and shall be held at specified places at least once every 2 months. Discussion meetings of the board shall be held on the second Monday of each month at 7:30 p.m. unless otherwise ordered by the board. And business meetings of the school board shall be held on the third Monday of each month at 7:30 p.m. unless otherwise ordered by the board. Special meetings may be called for special or general purposes and shall be open except when conducted as an executive session for purposes authorized by law. The president may call a special meeting at any time and shall call a special meeting upon presentation of the written requests of 3 school directors. Upon the president's failure or refusal to call a special meeting, such meeting may be called at any time by a majority of the school directors. No business shall be transacted at special meetings except named in the call sent to school directors for the special meeting. Public participation, each open board meeting prior to official action by the board, an opportunity shall be provided for public content in accordance with the law and board procedures. And then it basically lists out all of the voting requirements that they require for an adoption of majority of votes of those school directors present and voting, except as provided by statute or board procedures. All votes on motions and resolutions shall be by voice vote unless an oral roll call vote is requested by the president or another school director. Special voting requirements indicates actions for which the minutes must also reflect how each school director voted. These actions include actions requiring the unanimous affirmative vote of all members of the board remaining in the office to appoint as board secretary a former school director who has resigned before the expiration of term for which the member was elected, appoint as a solicitor a former school director who has resigned before the expiration of the term for which the director was elected. Actions requiring the affirmative votes of 2/3 of the full membership of the board include transferring during the first 3 months of the fiscal year budgeted funds set apart or appropriated to a particular item of expenditure, adding or increasing appropriations to meet an emergency or catastrophe, hiring as a teacher a former school director who has resigned before the expiration of the term for which the director was elected, conveying land or buildings to certain charities or other public agencies without following prescribed valuation procedures or with more favorable financing, incurring temporary debt, dismissing a tenured professional employee after a hearing, borrowing in anticipation of current revenue. Actions requiring the affirmative votes of 2/3 of those voting in the presence of the quorum include incurring temporary debt to meet an emergency or catastrophe, adopting or changing textbooks without the recommendation of the superintendent. Actions requiring the affirmative votes of a majority of the full membership of the board include fixing the length of a school term, adopting textbooks recommended by the superintendent, appointing the district superintendent and assistant superintendent, appointing teachers and principals, adopting the annual budget, appointing tax collectors and other appointees, levying and assessing taxes, purchasing, selling, or condemning land, locating new buildings or changing the location of old ones, creating or increasing any indebtedness, adopting planned instruction, establishing additional schools or departments, designating depositories for school funds. There's a million of these. We'll be reading these all night. Please feel free to read them on board docs, because there literally is a million more. I mean, maybe not a million, but it's pretty close. And then in addition to that, absenteeism from voting, a school director shall be required to abstain from voting when the issue involves either one of the following: a conflict of interest, or a relative recommended for appointment to or dismissal from a teaching position. The next section is minutes, and underneath here, the board shall cause to be made and shall retain as a permanent record of the district minutes of all open board meetings. Said minutes shall be comprehensive of the following, and it gives you a list of 8 items that the board minutes need to include. Board secretary shall provide each school director with a copy of minutes of the last meeting prior to the next one, and the minutes of the board meeting shall be approved at the next succeeding meeting and signed by the board secretary. Recess and reconvene. The board may at any time recess or reconvene to a reconvened meeting at a specified date and place upon the majority vote of those present. The next section here talks about how executive session works and what can be discussed in executive session. The next section talks about work sessions, and in here, what a work session is and how it can be utilized. And then finally, it talks about the implementation and use of standing committee meetings that can be called at any time by a committee chairperson.
Great. Does anyone have any questions or comments? Mr. Peterson?
This is quite similar to the current policy. It does go into some more detail, as Dr. Freeze just noted, about how many types of votes are listed. But there's no problem with that. It's an easy reference point for the board and administration to know for some additional topics what sort of votes could be required. It captures, I know some of you were on the board when the law changed with regard to those references to the agenda being posted 24 hours in advance. And we've all run in from time to time to the issue where something else comes up, but we have to take a pass on it because we can't meet that requirement. It does accurately reflect it. And there are some things in this policy that are found in current other policies of the district, but that's fine. Everything we have is consistent here with what we had in the past.
Great, then we can move that to vote next week. The next one is policy 006.1, and an addendum for attendance at meetings, but this is remote attendance at meetings.
Yep, this one just gives the authority of what the Sunshine Act talks about in terms of interpreted by Pennsylvania Supreme Court to permit members of a governing board of public agency to participate in public meetings, including deliberations, et cetera, in a remote setting. It talks about the guidelines for this. It talks about how they will access those meetings, how they are to notify the board president in the event that they need to be remote for the meetings. And then it also talks about how at the beginning of the meeting, the board president will let the public know if individuals will be telephonic, electronic, or use virtual communications for this particular meeting. In addition to that, they will be required to ask the person who is not present to vote and to verbalize that. And then if in the event that we have to convene entirely virtual, in such circumstances, the board shall ensure adequate means for public participation that allows everyone to still participate in the meeting. And then the last section here talks about the responsibility of administration to have the necessary equipment in order for these meetings to take place virtually if needed.
Great. Any questions or comments? Hopefully that'll never happen again, or the whole board is virtual.
Well, one matter, though, is that in April of 2020, the two important requirements here. One is that there physically be a quorum, or, in the room. And secondly, that the telephonic attendance only occur maximum 2 times per year unless there's some sort of health-related issue. The board suspended those as all boards did in 2021, or 2020 rather. And the language of the resolution is until further action by the board. All boards have had a physical quorum since the board started meeting again. But as a housekeeping matter, the board could, when adopting this policy, also rescind that to make it clear that this policy is fully in effect. Otherwise, there could be confusion as to whether or not, and of course, this then allows full virtual if there's some emergency. But it just, in reviewing this and looking at the old policy, I went back to the minutes and found that step was taken, but it's never been rescinded.
So, as written, board members participating virtually don't count toward the quorum?
That was suspended.
Right,
That- yeah,
suspended,
yeah.
but as it's written in the policy,
Yeah, as written in the policy, yeah.
okay.
So we always, there always had to be 5 people in the room to
Right.
have a quorum. And that's the way all of these policies read. Again, all districts suspended that. There was some confusion when meetings started becoming in person again, because the governor's office, which had allowed for total virtual attendance for all government agencies, rescinded that and said you have to meet in person again. And there was some confusion about people saying, well, how does that affect us? The answer is it doesn't. The school code has its own, provisions for that. So it's perfectly lawful for this board to suspend that requirement. But I just, put it to you that with the pandemic hopefully being, a distant memory, the board may want to, as a part of this resolution, because the exact language is that requirement remains suspended until the board takes action on it. One could argue that adopting this new policy constitutes that, but my suggestion would be to avoid any confusion, just make it part of the
That's fine. It's a requirement of the school code that there be 5 members in the room? Or is that just a policy?
No, that's a policy. Unlike other governmental bodies, there is no requirement that there be a physical quorum. It's by policy only. But nearly all boards, as you can see, since it's in the PSBA, and since nearly all school boards have adopted something like this, it's certainly the more common practice.
And there's a cap for any board member that wants or needs to participate virtually to 2 per year unless there's some health concern?
Here, let me read it verbatim.
I think it's 2 without notice, isn't it?
Well, policy BDEL, our current policy sets the limit of 2 2 times in a calendar year. Here, let me, rather than guess, I'm reading a new policy. I want to go back to the old one.
A board member may participate in board meetings by means of teleconferences 2 times in any calendar year. Is this what you're looking for?
Yeah,
That's in 006.1.
procedures. Oh, I'm on too many policies that start with BED. Board member may participate in board meetings by means of teleconferences 2 times in any given year. This limitation may be waived on a case-by-case basis. So where we have had board members recovering from surgery or something, then we've extended that.
And is the board president that,
It's a board majority.
okay, so that would require deliberate action by the board to waive the 2 virtual meeting limit?
Yeah.
Okay.
Yeah.
Mr. Peterson, I don't know if I see that in the new policy. What
Yeah,
I think I read is the last sentence of the second paragraph. Board members shall be able to attend a board meeting, establish a quorum, and participate in board deliberations and voting through telephonic, electronic, or virtual communications, but only with prior approval of the board president.
Yeah, right, yeah.
It doesn't
So-
set a number, it does allow quorum to be
Yeah,
present.
yeah, so our old policy set a higher standard.
Okay.
It-
I like the new policy, the way that it's reflected in the, I'm looking at, thank you, Dr. Davis. That quorum potentially can be established by virtual participation and there's not a 2-meeting cap, you know. but-
Yeah, I mean, obviously, this policy was written before Zoom was invented.
Sure.
It was, and before people became much more accustomed to
Yeah.
remote
I mean,
participation.
you know, but it gives the protective measure that it's with the prior approval of the board president, so
Yeah,
there's some accountability still.
Great.
Good, sorry, thanks.
No, thank you. Then we will move that forward next week.
and then we're gonna rescind the rescission on the other? The resolution we adopted in 2020?
Yeah, yeah. I
Yep,
think that's-
okay.
Yep, good business. Yes.
So the next one is 007, School Board Administration Communication Policy. This does not have a complementary policy that's currently in place, but the policy sets forth the communication protocol for school board members and school district administration members to carry out the public service they provide to the Mount Lebanon School District. And then it talks through all of the expectations. So the first, the superintendent or the superintendent's designee will advise the president and all other board members as soon as practicable on school or school-related developments that are controversial, sensitive to press reaction, involve public safety, or have legal implications. Likewise, with regard to such developments which first come to the attention of the board member, that board member will promptly advise the president and the superintendent of schools. Second is all board members' official communication with school district administration are to be initiated with or through the superintendent or appropriate administration liaison. Superintendent will designate that liaison responsible for each committee of the school board. School district administration will advise the superintendent of communication with board members, including school-related matters. All school board members' requests for school district information regarding school board business will be directed to and through the superintendent. It'll be the superintendent's responsibility to ensure timely provision of requested information. Should fulfilling a board member's request require significant use of staff time or cost to the district, superintendent may seek board approval prior to taking action. This provision is not intended to prevent administration from fulfilling its obligation, but to provide timely information under the right to know laws, but rather to manage the resource impact of information requests in a reasonable manner. The board president or committee chair, in collaboration with the superintendent of schools, shall establish the meeting agenda prior to the scheduled meeting. Subsequent to the publication of the agenda, new agenda items may only be added as specifically permitted by the law. See policy 006. And then superintendent's responsible for providing board members pertinent information about agenda items prior to the scheduled meeting. And then superintendent or designee is responsible for official communication with the press regarding school district matters. President of the board or designee is responsible for communicating with the press regarding official school board business.
Great. You've been doing a great job with this without a policy, so thank you. It's nice to have it in writing. Does anyone have any questions or comments? Perfect, then we will move that forward next week. The next one we're going to review is one of the last ones we're going to review is 011 Board Philosophy and Principles for Governance and Leadership.
Okay, for this particular policy, it is basically current policy BCA with some additions. So for this particular policy, it talks about board philosophy. It talks about principles for governance and leadership, and lists those out pretty specifically for both the board philosophy and the principles for governance and leadership. And rather than reading through all of these, because we have 3 minutes left, I'll just give like a high-level overview. Board philosophy is providing the finest educational program to staff the district, to provide best qualified teachers, to develop and promote among the students a full appreciation of the ideals of our American representative republic, to construct and maintain proper facilities, to develop a rigorous and academically stimulating curriculum. And then under the principles for governance, it has the areas of advocate earnestly, lead responsibly, govern effectively, plan thoughtfully, evaluate continuously, communicate clearly, act ethically.
Great. Does anyone have any questions or comments, Mr. Hoffman?
Well, yeah, I know we're short on time, and, but I did, the policy's one big step I've seen, one big positive step is the removal of gendered pronouns, which I've really appreciated, feel it's much more inclusive. I do think there's an opportunity here to add more anti-racist language into our policies as well. This in particular, I have sent some written documentation about some recommendations, but as you look down the policy, as it's written now with philosophy, leadership, let me get back over to it. And then what I believe are the PSBA governance and leadership principles: advocate earnestly, lead responsibly, govern effectively, et cetera. There are some opportunities there to add some language, such as to develop and promote among students an appreciation for equity, justice, and the diversity of our community, and to foster critical thinking about the ideas of democracy, including the importance of social justice and anti-racism. That's just one example, but again, I think it would be helpful and useful to the community to see more explicit language like that in the policy.
Thank you for your suggestions. I guess I have a couple comments. So thinking about, how we view through this lens of equity and everything we do in the school district, could we just add that, towards the board philosophy, like another number or bullet that addresses kind of a lot of the concerns
Well,
about the principles?
yeah, the thing that I personally don't like about that is then it becomes a separate thing as opposed to an embedded conversation. there's the separate DEI piece or whatever you would call it. And I think it's important to embed it throughout rather than separately.
Do you think in any way doing that, though, sort of dilutes the idea,
How so?
I mean, suggesting that we use, that language in every single piece of the I guess I agree with Mrs. Guth that if we could maybe add a bullet point somewhere that sort of addresses it in a different way rather than add that same language at every single place. I guess I just feel like it almost makes it less, I don't know. I feel like it makes it a little less impactful, I guess. I know that sounds opposite of what it should, but
Because then do you feel like we have to add provisions towards like our neurodivergent student population and students that are English language learners, or like if it's just,
yeah, I guess I just feel that, obviously I support all of this. But right, there are just so many other students. I mean, I could list a million. I mean, Mrs. Guth just said a few, but it's really all students, right? And so I think this language is important somewhere. But I think we're missing some of the population if we just focus on that alone.
Dr. Freeze, do you have any suggestions? As the subject matter expert for education.
I think that we need to have a discussion as a group as to where we place language and where we don't place language, right? Because I think that I hear both sides, right? I hear wanting to include it in every aspect of the policy, right? But then I also hear the dilution where we're repeating the same things, whereas we may not be adding other groups to that. And I don't think that we should be, as in a school district, always, we have to include everybody. And there are a variety of needs within the school district that we need to meet. So I think we almost need to come up with how we will move forward as a board. The equity statement is a huge piece of our philosophy and the work that we do. And is there a way to incorporate that in there? Because that does instill the values that the board, at least a couple of years ago, right, established. So how do we incorporate that into these policies so that it is a standard and it includes all students, no matter what their background is, their race is, their religion is, their disability may be, whatever it may be, it's all included within there. But I think that's probably a bigger discussion for us to have as a board.
Sure. So do you think moving forward that we don't want to move this forward? Or do we want to kind of think about integrating more of the equity statement in the board philosophy portion of this? Or do we want to have a broader conversation about how to integrate that in the principles of governance and leadership?
So we'll be meeting as a full board here in a few minutes to discuss all the proposed changes to this stuff. And there's a couple open issues I've kind of made a note of to bring to the attention of the full board and discuss. I think maybe we'll just throw that one out there also.
Perfect.
But, I mean, I think at this point, I agree with Dr. Freeze's suggested course in this, that our previously adopted statement, I view it as something that reaches all policies, all regulations, and all actions by the board as sort of a guiding light towards those things. And, I understand certainly that, Mr. Hoffman, your intent to take these and specifically build them out into this policy, but to Ms. Guth's point, then we start looking at all of the policies across the board and how do we weave these things in. But then sometimes when you start to make lists in an effort to include, you actually end up excluding those that aren't specifically delineated. So sometimes when you make things too specific, you may inadvertently be excluding, groups or people of, different positions or interests. So that's my concern.
I looked across the Commonwealth at other kind of urban or suburban peer school districts, including Philadelphia School District and PPS, and they have a very similar, like, philosophy and principles for governmental leadership as the PSBA. Philadelphia does have guidelines and guardrails that they've promulgated in conjunction with this policy that kind of gives more of a broader commitment to DEI-B and the support of our students. So that might be something to think about too, but.
Yeah, and Pittsburgh Public has one, or several as well, and I've shared that with you via
Yeah.
email in the past. There's certainly different pathways, and I do think it would be good to expand the conversation with the whole board as we are
Right.
meeting in a bit. But I do think it's important to have these conversations and be thoughtful about our approach.
Great, then we will move this forward to discuss in a couple of moments. The final policy that we are reviewing this evening is Policy 903, Public Comment in Board Meetings.
Policy 903 is taking a look at board meetings and how public comment is provided in meetings, as well as how recordings are utilized. And so for this particular policy, it talks about the purpose. It talks about how board meetings should be basically run in terms of public comment. For authority, it talks about the opportunity for district residents and taxpayers to provide comment on matters of concern, official action, or deliberation, which are or may be before the board. It talks about that copies of the agenda, which includes a listing of each matter of business that will be or may be the subject of deliberation or official action at the meeting, shall be made available to individuals at the meeting. The board requires the public comment on agenda items be made at the beginning of the meeting. And then it also talks about the public comment period at the conclusion of the discussion, regular and special meetings. In addition to that, it talks about if the board determines there is not sufficient time in a meeting for public comments, the comment period may be deferred to a next regular meeting or to a special meeting occurring before the next regular meeting. And then in addition to that, it delineates here an individual's public comment may be interrupted or terminated only under limited circumstances, such as when the individual's commentary is in clear violation of law or board policy, including but not limited to sexual harassment, racial, ethnic, religious, or nationality intimidation towards individual or individuals in the school community, disclosure of confidential personal information about students or staff, speech that traditionally has not been protected under the First Amendment, such as obscenities, defamation, and speech integral to criminal conduct, speech that constitutes true threats, such as inciting imminent lawless action or subjecting individuals to fear of violence, speech that does not concern matters that may come before the board for deliberation or official action, for example, sale of commercial products or services. Sign in and request a comment. Any Mount Lebanon resident or taxpayer desiring to reserve an opportunity to address the board, a discussion, business, or special meeting concerning agenda items should, by the Friday noon preceding the meeting, arrange with the office of the superintendent to be placed on the agenda at the beginning of the meeting, after the reports, and prior to board action on agenda items. And placement will be in the order that they're received. Others that are wishing, both residents or taxpayers, to address the board concerning items on the agenda will be given the opportunity to address the board at the beginning of each meeting, after the reports, and prior to board action on agenda items. In addition to that, there is the opportunity for those wishing to address the board concerning items on the agenda at the beginning of the meeting, or to comment on items of concern or other matters involving the school district via electronic means. This is intended to be a public service, but is not a legal requirement. The lack of public comment via electronic means, whether due to equipment malfunction or other technical problems or otherwise, shall have no impact upon the conduct of the meeting or affect the validity of action lawfully taken at such a meeting. Prior to public comment during the meeting, the presiding officer may make a statement providing direction and establishing expectations. Public comment, individuals shall wait to be recognized by the presiding officer. The public comment session at the beginning of the meeting shall be limited to no more than 1 hour. The second public comment period shall be limited to no more than 30 minutes. Each statement made by a participant shall be limited to 3 minutes. And then it basically goes through how that time can be used. Like, you can't come up and talk about the same topic twice, for instance, unless there's time still available, correct, Tom? And then it basically gives the presiding officer and the district solicitor the authority to interrupt an individual to warn the commenter that the statement's too lengthy or conduct is in violation of policy. After the warning, they can terminate the individual's opportunity to comment when the conduct continues. They can call a recess or adjourn to another time when the individual's conduct is otherwise in violation of the policy. They can request an individual to leave the meeting when their conduct is disruptive. They can ask the person to leave, and if they do not leave, they can contact law enforcement to have the individual removed. Or they can waive the board's rules regarding public comment with the approval of the majority of those present in voting. In addition to that, it talks about the response to public comment, and that public comment in board meetings is to allow the board to learn the thoughts of the public prior to the board deliberation and official action. That although the public comment period of the meeting is not a question and answer session between the public and the board may direct staff to follow up and address public inquiries in a reasonably prompt manner. And then the last part here talks about the recording and release of meetings and public comment. It basically states that the discussion meeting and business meetings will, where practical, be recorded. Recordings will be aired on the district's cable channels on subsequent days for a length of time and frequency to be determined by the district. And then in addition to that, the board meeting's intended to be a public service, but it's not a legal requirement. Lack of recording or broadcasting, whether due to equipment malfunction or technical problems, should not have an impact on the conduct of the meeting or the validity of the action taken. Recording of any public board meeting produced by the district is the exclusive property of the district to be used at the board's discretion. Recording of any public board meeting produced by the district is not an official record and is not a public record available for the district for inspection and copying. The board-approved written minutes will continue to be the official record of the meeting. And then in addition to that, there's a couple of more things that are related to the intent of the broadcast recorded board meetings in their entirety. It is at their discretion, however, to depart from that intent until further under certain circumstances, such as the board at any time by majority vote of the quorum in attendance at the public meeting. If a recording becomes impractical due to equipment, they can basically say it won't be utilized, or the board may have the recording of a meeting edited prior to the broadcast in order to avoid possible legal liability to the board, the district, or the district employees, and to otherwise avoid distribution of statements that would disclose confidential information about students or staff. Do not concern matters that may come before the board for deliberation, constitute sexual harassment, racial, ethnic, religious, or nationality intimidation towards an individual, are abusive, obscene, disruptive, potentially defamatory, confidential, and/or privileged, constitute speech that has traditionally not been protected by the First Amendment, are profane, or contain true threats. And the board president, acting upon advice of the solicitor or other appropriate legal counsel, will determine their sole discretion which portions, if any, of the recordings will not be broadcast. And then any board member, district employee, or any person who believes they have been defamed by the board meeting should notify the board president or superintendent. After the broadcast, the original recording containing the audio or video of the public board meeting produced by the district may be erased, reused, and/or disposed of at the discretion of the district. The next part here talks about public comment recorded in minutes. It does allow for the names of the citizens who appeared before the board and the subject of their testimony. For committee meetings called for the purpose of deliberation shall be open to the public, and all relevant provisions of this policy shall be applicable to those meetings. And then finally, electronic recording devices and cameras, in addition to those as official recording devices, shall be permitted at open meetings. The board is authorized to establish reasonable rules for the use of recording devices and cameras during board meetings to ensure that they can conduct their meetings and the maintenance of the order of those meetings.
Thank you. Does anyone have any questions or comments? Mr. Hoffman?
Yeah, I mean, most of my feedback is similar too, so I think the discussion we'll have and the discussion meeting will apply, but there is one specific call out on page 4, under public comment, a line saying that the second public comment period shall be limited to no more than 30 minutes. Why are we limiting the number of minutes for that public comment session?
I could advise on that if you'd like. Our current policy doesn't have that limit. The only reason that's in there is the PSBA policy template has it. If this board doesn't want to have that particular time limit. In fact, the PSBA template gives an array of the amount of time, and 30 minutes is the longest one in their choice. Our policy has always been somewhat more fluid, so that, for instance, if there is a huge agenda, the board might have to reduce the time in the early discussion point in order to have time to vote on everything it needs to vote on. So that particular issue it's totally up to the board. Again, what you see here in almost every policy that has been reviewed is the starting point was the PSBA policy. This is an area where Mount Lebanon's policy traditionally has been somewhat different. It never had those time limits. So the board could discuss that. The only other thing I would note is this policy has, there's been a significant amount of litigation over some of these topics, particularly since the pandemic, with regard to what sort of speech can be stopped, et cetera, that quite frankly would be more appropriately discussed in executive session before any final action by the board. I mean, certainly we could also provide a memorandum, but there's just some developments that are significant.
So it's your suggestion, Tom, that before the board votes to adopt the new policy, that we've been provided with some additional information regarding the current state of the law?
Yeah, and I also feel that it might help, it would help the board's discussion and make it more effective to know what some of these new rules are, rather than perhaps going in a direction that could present legal exposure.
Okay.
So,
And that's just for this policy 903.
yeah, this one.
Sure, we could do that and discuss this next week.
Well, yeah, why don't we bring it up to the board, then we'll decide whether or not to put it forward at the discussion meeting shortly, and then decide whether or not to put it forward for a vote this month, or maybe hold off for an executive session and/or memorandum from council.
Yeah, I mean, there's gonna be, of course, a group of policies every month, so
Yeah.
you control
We'll do this again.
the pace of it, but everything else we've talked about today was more practical issues, but this would involve, in my view, some privileged discussions.
Thank you.
Thank you.
Can I just do a quick summary, Claire, just so, or Mrs. Guth, so that I can make sure that we're all on the same page? So for the small kind of like technical non-technical things that were in here, like spelling and things like that, those have already been made into the drafts. Anything that we've said that we would hold for further discussion has not been updated. Policy 000, local board procedures, is replacing current policy BG, so that would be retired. Policy 001, name and classification, would be replacing current policy AA. Policy 002, authority and powers, would be replacing current policy BBAA. 003, functions, would be replacing current policy BDD. 004, membership, would be replacing the current policy BBE. 005, organization, would be replacing current policies BDA and BDE. Policy 006 for meetings would be replacing BEA, BEB, BEBA, BEC, BEDA. 006.1, remote attendance at meetings, would be replacing current policy BEDL. 007, school board administration communication policy is new. 001, board philosophy, principles for governance and leadership, would be replacing current policy BCA. And then policy 903, public comment in board meetings and recordings, would be replacing policy BEDH and BEDJ. And finally, policy 918, Title I Parent and Family Engagement would be replacing current policy KC. I just wanted to make sure I gave that summary.
Thank you. That's great. So one final thing, we wanted to touch base with everyone to discuss the Markham to Mellon and Jefferson Middle School guidelines that were created in 1997.
Is that on the agenda?
It's not on the agenda, we just wanted to talk about it.
We can't.
Do it
Okay.
next month.
Oh, we'll do next month. Great. And we just discussed that policy and why that's important. So not 24 hours notice. Great. Then if anyone has any other questions or comments, I will adjourn and we can move forward.
Motion to adjourn.
Oh, thank you, motion adjourn. Do I have a second?
Second.
Thanks. All in favor?
Aye.
Aye.
Aye.